Welcome to Can Confidential, the Karen Reed murder trial. We remain on jury watch. The selection process took a step backward today before taking a step forward. Good evening, and thanks for joining us tonight. I'm Glenn Jones. JC is off. Today we learned one juror dropped from the panel, bringing the count back to 15, but another was seated, so now we're back up to 16. Also this today, confirmation the Commonwealth plans to use Reed's own statements outside court while prosecuting her inside court. She's been the central character in a number of documentaries, as you know. Now the Commonwealth hopes to use Reed's words to its advantage. Before we bring in our experts, let's get caught up on today's court proceedings. Our John Maroney has those details from Norfolk Superior Court in Denham.
I'm okay with it. We can use time.
Karen Reed right back where she finished last week with 16 jurors, even after 9 days of jury selection. The 45-year-old defendant says she's been framed, pleading not guilty to hitting her boyfriend John O'Keefe with her SUV and leaving him to die in the snow.
It is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt.
More than 500 potential jurors have been screened for the high-profile case, all of them filling out a 3-page survey with questions about the defendant, law enforcement, and media coverage. The court has allowed some of the seated jurors to drop out because of personal issues.
The reality is that all of these jurors know about the case. The question is how many of them will honestly state that they can be completely impartial.
Judge Beverly Cannoni asked the 56 potential jurors in Monday's pool about their knowledge of the case. 90% said they've heard of it, 44% say they formed an opinion, and 7% say they have a bias either for or against Karen Reed.
The defendant starts this trial presumed to be innocent.
Reed has been involved in the selection process. Instead of the defense table like last time, she's sitting near the sidebar within earshot and view of the private conversations between the jurors, judge, and attorneys.
The more times they can look at someone and perhaps start to relate to them, the much harder it is to then say guilty at the end of this process.
The 16 jurors are still evenly divided between men and women, 8 and 8. They're still looking for 18 before testimony begins. Jury selection resumes tomorrow. In Dedham, John Maroney, NBC 10 Boston.
John, thank you. Michael Coyne, our chief legal analyst and dean at the Massachusetts School of Law, joins us now. Michael, good to have you back around the table for another week.
Thanks.
All right, so net zero on jury selection today. Any chance we get to opening statements this week, do you think?
I do. I think we're a day or two away from wrapping up the jury selection, and whether she gives them one day off to prepare or not, I think we'll see them by the end of the week.
All right, so let's get people at home ready. Before the trial starts, let's get a refresher on the charges Reed is facing. There are 3, of course: second-degree murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a collision causing death. Michael, can you explain the burden the Commonwealth needs to reach on these 3 charges? And, of course, what we learned in the first trial when it comes to splitting the verdict.
Yeah, sure. I mean, the top charge there, the second-degree murder, is the most difficult charge that the Commonwealth has to bring to bear here. And they're going to have to show that she did have an intent to hit him, even if it didn't kill him, but that grievous injury occurred as a result of it.
Right.
I think that's a tough sell. The middle charge, the vehicular manslaughter, in essence, the driving under the influence while having consumed enough alcohol that her ability to drive was impaired, that still carries with it a mandatory minimum jail sentence. And that's the one I think she's most at risk of.
And being negligent is enough to be convicted on that charge.
Exactly. You don't require the intent to hit him. All it is that you have consumed alcohol to the point where now your ability to drive safely has been impaired, and his death occurs as a result of that.
And in the first trial, it is on charge 1 and charge 3 that many jurors have come forward to say they were unanimous on acquittal.
And that's correct. And the third charge, which has really not made that much sense to me, that they could eliminate that, because if she's guilty of vehicular manslaughter, driving under the influence, causing John O'Keefe's death, then didn't she leave him in the snow to die as well? So 2 and 3, to me, seem very closely related. And I think those are the charges she stands the most at risk of.
All right. Well, we do have a viewer question we want to get to, Michael. The
Sure.
first is from Bruce in New Hampshire. He wants to know, is it possible the retrial could also end in a hung jury or mistrial? And if that does happen, what happens next? I like to refer to this as the nuclear option. Could we get a third trial?
Yeah, I think we could. I mean, I think if one looks at this, if this jury pool, if this case proceeds like the last one did, and the jury is as split as the public are, right, that we could end up in the same place again. I do think we're going to see a slightly different presentation by the Commonwealth and a different presentation by the defendant as well. So you may get a result this time, but it would not be surprising that this jury also will be just as split as the public is about Miss Reed's guilt or innocence.
My goodness. All right, let's try to get to one more quickly. This question is about State Trooper Michael Proctor. The question is, once he was the lead investigator in this case, he was, of course, dishonorably discharged from the force last month for his actions during the investigation. You may remember he sent crude text messages about Reed to his friends and family during the first trial. Jurors learned about this through his testimony, but a lot has happened since then, Michael. So Ed wants to know if Trooper Proctor lost his qualified immunity being dishonorably discharged from the MSB, can he be charged with perjury in this case? But before you answer, maybe we could kind of lower the bar on Ed's question just a little bit. Instead of perjury, what if the jury just knows in the second trial that he's been fired? Does everything that he was involved to become tainted in the eyes of the jury, do you think?
Everything is potentially tainted because of his actions that were revealed in the first trial. There's no doubt about it. His presence in this trial, just like last trial, is toxic. And so the Commonwealth may very well try to cover his testimony with other witnesses. And if, in the event, they do have to call him, and if they don't, the defendant will likely
100%.
call him. He, like every other witness in a case, would still be subject to charges of perjury if, in fact, he lies, or any witness lies about material items in their testimony.
That's going to be a fascinating story to follow in this trial. All right, Michael, stay right there. Circling back to the discovery paperwork filed today, the Commonwealth showed the defense a list of Karen Reed interviews they intend to use. Remember, Karen Reed did not take the stand in her first trial, but she has been talking, most recently in an investigation discovery docuseries where Reed herself mentioned her words were her testimony. Here's a clip.
Doing this film is my testimony. I want to say what happened exactly as it happened.
All right, our courtroom insider Sue O'Connell has joined the table now. Sue, of course, you were in a couple of those documentaries, so you know them very well. What's your take on the impact of Reed's own words used by the Commonwealth in this second trial?
Well, we didn't hear her voice except on the voicemails in the first trial. And, you know, as we all know, you are not required to defend yourself. You don't need to take the stand. Your lawyers actually don't need to do anything at all except show up at court. So I think this is really going to change the dynamic of the prosecution's argument and be able to give a fuller picture of Karen to the jury, right? So how they take that is going to be up to them, but it won't just be what people said about her and the voicemails that we heard. It's also going to be her own words describing. And there are inconsistencies. There's a lot of inconsistencies about where John went when he got out of the car, where she went when she went looking for him, all sorts of things that could come into play. But again, how the defense spins this and what the prosecution spins this as, we're going to have to wait to see what the story is there.
Do you think Reed is going to come to regret the amount of which she has spoken since the last trial?
I do. I mean, many of us have said it's really not a smart strategy to be as vocal and as available to the media as she has been. Even as she leaves the courtroom every day now, she's talking to John, talking to Melody. The problem is that those statements will be used against her. The party's own statements in Massachusetts and under the federal rules of evidence are admissible if the adversary wants to put them in, and they will. So it's not hearsay by definition. And the interesting part of it then will be, will they, her side, try to introduce some of the other portions of those out-of-court statements? They will argue to put it into context. There's a rule of completeness that says, well, if one side puts in a portion of the information, shouldn't the other side, in fairness, be allowed to introduce others? And they will very well may try to introduce information, one of the key pieces being, at some point she says, I saw John go in the house. she would be the only person that puts him inside the house. So
I just
that'll
wanna-
be an
yeah.
interesting battle here.
I sat for 8 hours over 2 days, so they certainly have lots and lots of video.
No doubt.
So.
Yeah. All right. As we wait for opening statements to begin, we did get an interesting payroll document we'd like to share with our audience. Take a look at this. The trial hasn't even started yet, but Hank Brennan, the special prosecutor for the Commonwealth, has already racked up nearly $250,000 in costs to the taxpayer. So I want to ask you both about this. Michael, first to you. Is this good value for money when it comes to just the legal aspect? And Sue, is there any potential political fallout around this? Because, of course, this was the decision of an elected official.
It is good value. I forget what his hourly rate is under the contract, but it's well below what he would be charging to a private client in a case of murder. So they're getting good value. The problem is there's a ton of hours involved in this case. We're far from done. That number's likely going to double before we're done.
I think you're probably right.
And so it's hard to tell the public that we're getting value at $250,000 or $500,000.
Well, speak of the politics of
Yeah,
this.
so the money's in the budget. DA Morrissey's in charge of the budget. He can spend it the way that he wants. The question will be for voters, right? In Norfolk County, was this the best decision to hire Hank Brennan? Was it the best decision to charge Karen with murder? Was it the best decision to retry her and charge her again with murder? We're not going to know the answer to that until voters go to the polls or until we have a conclusion to this race. I mean, I spoke to so many people during the first trial outside who didn't understand that they voted for district attorney. Right? They didn't think of it as an elected office. They don't live and breathe it like we do.
Right.
And the thought that they could fire someone based on who they prosecuted or how they prosecuted, these are your tax dollars, right? And Norfolk County voters are going to have to decide if it was best spent that way.
They all know who the elected official for DA is in
Now.
Norfolk County now. Thank you both very much. And thanks to all of you as well. Be sure to tune in to Canton Confidential, the Karen Reed murder trial. Every weeknight at 7, we'll have a full recap of the latest developments from court, as well as legal analysis. And don't forget, as you just saw, we want your questions about this case. Send them our way. We've got the email up on your screen right now. We'll answer as many questions as we can right here on Canton Confidential.